Yeah. 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 So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of conflicts or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect, and happy Valentine's Day. Happy Love Day to you. I hope you guys are having a fantabulous day. If you can do me a favor and hit the like button as you come into the building and subscribe to the channel if you have not done so already. First and foremost, I have to thank Granny the Great for the super chat. Thank you so much. I appreciate that. She said, Happy Valentine's Day to all the intellects. I hope you guys are having a great day. My son said, Resign, Eric Adams. Got too many people in the pocket, it looks like. Not saying a definite accusation. He said it's allegedly upon information and belief. But yeah, we are here to talk about Eric Adams. Okay. Now, in my membership, there was an article of which they said that Eric Adams' charges was going to be dropped. I hadn't seen a motion. I told you guys, I said, I'm not really going to talk about it because I'm checking the docket. Nothing is happening on this docket. Nothing is moving. Nobody has filed anything. So I don't really want to talk about it. Well, the reason why nothing had been moving is because don't nobody want to be the one to do it. Okay? Nobody wants to be the one to do it. I got all these. Y'all see the balloons? I got they all over the house. See these balloons? Y'all see them? Let's see. I think there's one over there. So they might be floating over here because they all over. Oh, all over the room. I feel so loved. Then Dev got me these flowers. You guys see the flowers? Let me see. This is my good side. Oh, hope you guys feel loved on today's day. If you don't, I love you, okay? I love each and every one of you guys, but I hope you guys are having a great day. Thank you so much, Alma. You said happy love day, everyone. Thank you for all your hard work. Thank you so much. I appreciate that. Aren't they pretty? They smell good too. So thank you so much. Thank you. Thank you. Thank you. So yeah. We talking about Eric Adams today. I thought I was gonna be talking about Jake's. No, I didn't really think so. I figured they'd try to wait till the last minute. Well, let me double check before I get started on this. But we're gonna talk about Eric Adams and why I don't know what's happening over. Well, the whole United States of America is just under distress right now. It's things that are happening that is unprecedented. And this is one of those, to have the DOJ send a letter and say, hey, we're going to need you to drop these good charges. That's not how this thing works. And I think it was just a preview of how the Justice Department is going to be ran. And some of these AUSAs, that's assistant U.S. attorneys, or even the U.S. attorneys who are the head of it, They don't want to be a part of it. They don't want to be a part about how they don't want to be a part of how this is moving, because regardless to your position as attorneys, I know some people talk about lawyers and they, talk about us real bad. But we did take ethical oaths. We have oaths that we take, then we're supposed to uphold. And the way this is moving is not according to the oath that we all took when we became. Tai said, I'm not waiting around for Jake's all day today. I'm on my way to get me a veggie burger. I hear you. But I'll let you know as soon as it drops. I'm going to let you know. Because I just want to know what Jake's has to say on all of these shenanigans. Good afternoon, Cases and Cams with Danielle Cunningham. Good to see you. I don't think I've seen you in a while, Danielle Cunningham. And you didn't have Cases and Cams on there. But it's good to see you. U.S. seniors need love too. Thank you so much. Thank you. Thank you. I appreciate that. Are you guys hitting that like button so that we can get in this good algorithm? Diamond, Pearls, and Gems said, who wants that mess on their resume? Exactly. Just to give a brief summary, remember Damian Williams, who is the one that indicted Eric Adams and also indicted Diddy, he resigned as soon as not Biden, I said he lost the election, Lord have mercy. As soon as Kamala lost the election, he resigned in December. See, a lot of times they're like, I resign, you ain't got to kick me out and fire me. Because you see, our president had a memo of lists of people, even like Keisha Lance Bottoms. Like, a lot of them resigned ahead of time because they already knew what was up. They knew that if he got in office, he was going to get rid of everybody. So they just said, you ain't got to kick me out. I don't want to be nowhere that I'm not wanted. And so pretty much they left. So when this situation happened, that means that Trump appointed someone to take his position, Damian Williams. This U.S. attorney, when this memo that we are about to read came out, she resigned. She was like, nah, we not, the way this is moving. She just said, I'd rather resign. That's just what it is. So what memo am I talking about? I am talking about this DOJ memo that people have talked about in articles that was circulating, but this is the actual memo, okay? And this is from the acting deputy attorney general on February 10th of 2025. You are directed as authorized by the attorney general to dismiss the pending charges in United States v. Adams as soon as practicable, subject to the following conditions. Number one, the defendant must agree in writing to dismissal without prejudice. Number two, the defendant must agree in writing that he is not a prevailing party under the Hyde Amendment Public Act 105-119. And three, the matter shall be reviewed by the confirmed U.S. attorney in the Southern District of New York following the November 2025 mayoral election, based on consideration of all relevant factors, including those set forth below. So they're saying it needs to be dismissed without prejudice, which means that they can bring it back. However, they cannot bring it back until the appointed U.S. attorney of the Southern District of New York do their own investigation as to whether these charges should have been brought in the first place. And these are the steps within, they say there shall be no further targeting of Mayor Adams or additional investigative steps prior to that review. And you are further directed to take all steps within your power to cause Mayor Adams' security clearance to be restored. So apparently, once he was indicted, his security clearance went with it. The Justice Department has reached this conclusion without assessing the strength of the evidence or the legal theories on which the case is based. which are issues on which we defer to the U.S. Attorney's Office at this time. Moreover, as I said during our recent meetings, this directive in no way calls into question the integrity and efforts of the line prosecutors responsible for the case or your efforts in leading those prosecutors in connection with the matter you inherited. However, the Justice Department has determined that dismissal subject to the above described conditions is necessary for two independent reasons. First, the timing of the charges and more recent public action by the former U.S. attorney responsible for initiating the case, i.e., Damian Williams, have threatened the integrity of the proceedings, including by increasing prejudicial pretrial publicity that risks impacting potential witnesses and the jury pool. So basically, they have pulled up the argument that Spiro, whatever his last name is, that is representing Adams. Remember, he filed a motion basically saying that a lot of stuff was getting leaked to the media and it would affect the jury pool, which was shot down by the court. Well, this acting attorney general basically said, yeah, that's a problem. And that needs to be looked into as to why this happened, like the integrity of these proceedings. So it's kind of talking about Damian Williams, who has already resigned. It cannot be ignored that Mayor Adams criticized the prior administration's immigration policies before the charges were filed. So they're making it seem like he was targeted because the Biden administration criticized the way he was handling immigration. Because, you know, that's the new thing right now with the immigration. They're trying to send everybody back. So they're alluding or insinuating that the timing just cannot just be coinky-dink. It has to be pretty much because of the criticizing of the Biden administration. And the former U.S. attorney's public actions created appearances of impropriety that implicate the concerns raised in the Attorney General's February 5th, 2025 memorandum regarding restoring the integrity and credibility of the Department of Justice, as well as the Executive Order 14147 entitled Ending the Weaponization of the Federal Government. These actions in the underlying case have also improperly interfered with Mayor Adams' campaign in the 2025 mayoral election. I need to know how many people in this chat plan on voting in New York for Mayor Adams. I'm just saying. In New York, how many people plan on voting for Mayor Adams? Because they're saying it's going to interfere with his election. Okay. Second, this is the second reason why they want this action to happen. The pending prosecution has unduly restricted Mayor Adams' ability to devote full attention and resources to the illegal immigration and violent crimes that escalated under the policies of the prior administration. Y'all see the pattern here? All of this is making it seem like somehow, see, it sounds like Adams used the talking points so that he can look like, just like Trump, he was somehow targeted. So I'm against illegal, I'm against immigration too. I was trying to do something about it in New York, and I got criticized by the Biden administration. We are particularly concerned about the impact of the prosecution on Mayor Adams' ability to support critical ongoing federal efforts to protect the American people from the disastrous effects of unlawful mass migration and resettlement, as described in Executive Order 14165. Accomplishing the immigration objective established by President Trump and the Attorney General is every bit as important, if not more so, as the objective that the prior administration pursued by releasing violent criminals such as Victor Bout, the Merchant of Death, accordingly. So it has, according to an October 2024 Wall Street Journal article, Bout has already started to participate in arms deals again, including negotiations with representatives of Ansar Allah, also known as Houthis. So is this the person I think that we exchanged Brittany Griner for? Is that who they're talking about? The person we exchanged for Brittany Griner for? So they're just throwing little things in here that just doesn't make sense to me. But Tracy said, I'd rather sit in the cold and wait outside for days to vote him out. Well, how do you really feel, Tracy? How do you really feel? Call me darling said Adams did nothing but elevate himself. He made sure to go to every concert, club, and any event that has celebrities. Outside of that, he didn't do anything. I am taking my 92-year-old granny out to vote to get him out. We not mailing nothing. Well, apparently he think remember that was their biggest talking point with his attorney, was saying that this is interfering with they were trying to hurry up and have the trial like in March as soon as possible because they don't want this to interfere with his election. And I was like, and then I was asking you guys, I'm like, are y'all plan on voting for him or not? So he apparently feels like he does have a chance to get reelected. Nettie said it all sounds like BS to me. Yeah, that's what I think. It's going to end up happening where a lot of people from New York, this right here is a bad look. A lot of people in New York are going to show up, like you said, in droves, and they're going to, whoever, I don't know who he's running against, but they probably got a better chance now, even better chance now, because they just want to get him up out of there. Star Bell said a big no. I guess she's not voting for him. Okay. Accordingly, based on these additional concerns that are distinct from the weaponization problem, dismissal without prejudice is also necessary at this time. So that is the letter of which a lot of the press had, and they did newspaper articles because of the dismissal. So I was just watching the docket like, okay, well, when they plan on dismissing this case? And it just never happened. But one of the reasons is all of a sudden people just started resigning. So you had the acting attorney general resigned, and then I guess it was someone else that was supposed to do it. But this is the letter that made me go ahead and do this live, because I was reading it and I was like, this is funny to me. So let me see. Let's see if it comes up. So this was a letter from Assistant U.S. Attorney Hagen Scotton, who also resigned. Mr. Bove, or Bove, whatever, however you say his name. I have received correspondence indicating that I refused your order to move to dismiss the indictment against Eric Adams without prejudice, subject to certain conditions, including the express possibility of reinstatement of the indictment. That is not exactly correct. The U.S. Attorney Danielle R. Sassoon never asked me to file such a motion, and I therefore never had an opportunity to refuse. But I am entirely in agreement with her decision not to do so, for the reasons stated in her February 12, 2025 letter to the Attorney General. So that was a whole nother letter that was sent by the actual acting Attorney General. In short, the first justification for the motion, that Damian Williams' role in the case somehow tainted a valid indictment supported by ample evidence and pursued under 4 different U.S. attorneys, is so weak as to be transparently pretextual. So as you all said in the chat, he basically said in a nice way, it's BS. The second justification is worse. No system of ordered liberty can allow the government to use the carrot of dismissing charges or the stick of threatening to bring them again to induce an elected official to support its policy objective. So basically, you're holding something over Adam's head where he can always have this reinstated, but you're basically compelling him, I guess, to agree with your policies. And you're a mayor of you're a mayor of a city. Let's go. There is a tradition in public service of resigning in a last ditch effort to head off a serious mistake. Some will view the mistake you are committing here in the light of their generally negative views of the new administration. I do not share those views. I can even understand how a chief executive whose background is in business and politics might see the contemplated dismissal with leverage as a good, if distasteful, deal. But any assistant U.S. attorney would know that our laws and traditions do not allow using the prosecutorial power to influence other citizens, much less elected officials, in this way. If no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who is enough of a fool or enough of a coward to file your motion. But it was never going to be me. Please consider this my resignation. It has been an honor to serve as a prosecutor in the Southern District of New York. If I ever have to resign anywhere, this is how I would like to go out. He said, but it was never going to be me. Crooks of the same flock fly together. For always forever said his whole campus resigning or getting indicted. It should have been clear when Kigo Sewell resigned, a police commissioner, after 6 months and went back to Nassau County. See, the thing is, two other individuals that worked with Adams were indicted as well, or they were about to be. I think they were indicted, but in January, like in a conspiracy, a part of the conspiracy claim. But one of the guys already said he was going to plea. So I don't think that's why we haven't seen it plastered everywhere, because he's already given his decision, I guess, that he's going to plea. These AUSAs, they're going to mess around and not have any. That's exactly what he may have to do, is actually get one of his own attorneys to go on over there and do what he's requesting that they do. Because it sounds like these individuals are standing on business and integrity. You said today might be tell it like it is. Yeah, I mean, you have to give it to them. It's just, yeah. So as of today, and this was just supposed to be a quick update because I did mention Eric Adams and the whole resignation and all of that. As of today, no one has bit the carrot to dismiss his indictment. So he is still indicted. Things are still being filed as we speak. They filed a protective order, I think, today or yesterday. So, yeah, that's just where they are. They're trying to find someone that is willing to do it, because it does sound like it. It's like, we're going to dismiss it without prejudice, meaning we can bring it back. You come out with reasons saying you feel like the jury pool is tainted and some other reason. And you feel like he was targeted. Basically, Adam's talking points is really what they said. So now they're making it seem like that's their reasoning to say they can request a dismissal. But then they have all these contingencies that to me sound like clarion calls out to Adams that you better be in conformance with what we trying to do over here with this administration and not be a part of the pushback and the fight back what we're trying to do for immigration. And so there was a meeting, I think the same day that this letter came out, or around the same time that the letter came out, not from this AUSA, but from the actual original letter. And they showed a picture of a round table. And Adams has already come out trying to talk about, people were asking him how he felt about the dismissal. It's definitely coming with a bunch of contingencies. This, I scratch your back, you scratch mine. That's what it's looking like. So you said she probably said, hell no, I'm out of here. They never gave a reason why she left. She got up out and yeah. So yeah, that is what's up. Let me see if I can find what is her name? Danielle Sassoon. I don't think I read her letter. Let's see. See if I can find her resignation letter. Let's see. Okay, let's read her letter. Because I see her letter now. Let's see. Okay, let's read the original, the acting U.S. Attorney General. So hers was on February 12th, 2025, and it had, Dear Attorney General Bondi, on February 10th, 2025, I received a memo from Acting Deputy Attorney General Email Bove directing me to dismiss the indictment against Mayor Eric Adams without prejudice, subject to certain conditions, which will require leave of court. So yeah, that's why I was waiting. I'm like, they got to get permission from the court for that. I do not repeat here the evidence against Adams that proves beyond a reasonable doubt that he committed federal crimes. Mr. Bove rightly has never called into question that the case team conducted this investigation with integrity and that the charges against Adams are serious and supported by fact and law. Mr. Bove's memo, however, which directs me to dismiss an indictment returned by a duly constituted grand jury for reasons having nothing to do with the strength of the case, raises serious concerns that render the contemplated dismissal inconsistent with my ability and duty to prosecute federal claims without fear or favor and to advance good faith arguments before the court. When I took my oath of office 3 weeks ago, I vowed to well and faithfully discharge the duties of the office on which I was about to enter. In carrying out that responsibility, I am guided by, among other things, the principles of federal prosecution set forth in the Justice Manual and your recent memoranda instructing attorneys for the Department of Justice to make only good faith arguments and not to use the criminal enforcement authority of the United States to achieve political objectives or other improper aims. I am also guided by the values that have defined my over 10 years of public service. You and I have yet to meet, let alone discuss this case. But as you may know, I clerked for the Honorable J. Harvey Wilkinson, the third on the U.S. Court of Appeals for the Fourth Circuit, and for Justice Scalia, I said Scalia, Lord. Justice Scalia in the U.S. Supreme Court. Oh, okay. All right, sis. Both men instilled in me a sense of duty to contribute to the public good and uphold the rule of law, and a commitment to reasoned and thorough analyses. I have always considered it my obligation to pursue justice impartially, without favor to the wealthy or those who occupy important public office, or harsher treatment for the less powerful. I therefore deem it necessary to the faithful discharge of my duties to raise the concerns expressed in this letter with you and to request an opportunity to meet to discuss them further. I cannot fulfill my obligations effectively, lead my office in carrying out the department's priorities, or credibly represent the government before the courts if I seek to dismiss the Adams case on this record. She says the government does not have a valid basis to seek dismissal. Mr. Beauvais' memo identifies two grounds for the contemplated dismissal. I cannot advance either argument in good faith. As you know, the government may, with leave of court, dismiss an indictment under the federal rules. The principal object of the leave of court requirement is apparently to protect the defendant against prosecution or harassment, e.g., charging, dismissing, recharging, when the government moves to dismiss an indictment over the defendant's objection. And that's in Rinaldi v. U.S. But the rule has also been held to permit the court to deny a government dismissal motion to which the defendant has consented if the motion is prompted by considerations clearly contrary to the public interest. The reasons advanced by Mr. Beauvais for dismissing the indictment are not ones I can in good faith defend as in the public interest and as consistent with the principles of impartiality and fairness that guide my decision making. So basically, since they gotta get leave from the court, they may have to argue this. And she's saying, I don't have any arguments. All right. The arguments that you're saying are weak and make no sense. First, he proposes dismissing the charges against Adams in return for his assistance in enforcing the federal immigration laws, analogizing to the prisoner exchange in which the U.S. freed notorious Russian arms dealer Victor Bout in return for an American prisoner in Russia. Such an exchange with Adams violates common sense beliefs in equal administration of justice. The commitment to the rule of law is nowhere more profoundly manifest than the criminal justice system. Impartial enforcement of the law is the bedrock of federal prosecution. As the Justice Manual has long recognized, she knows this manual, okay? She has read this manual backwards and forward. As the Justice Manual has long recognized, the rule of law depends upon the even-handed administration of justice. The legal judgment of the Department of Justice must be impartial and insulated from political influence. But Adams has argued in substance, and Mr. Beauvais appears prepared to concede that Adams should receive leniency for federal crimes solely because he occupies an important public position and can use that position to assist in the administration's policy priorities. Federal prosecutors may not consider a potential defendant's political association activities or beliefs. If a criminal prosecution cannot be used to punish political activity, it likewise cannot be used to induce or coerce such activity. Threatening criminal prosecution, even to gain an advantage in civil litigation, is considered misconduct for an attorney. In your words, quote, the Department of Justice will not tolerate abuses of the criminal justice process, coercive behavior, or other forms of misconduct. Dismissal of the indictment for no other reason than to influence Adams' mayoral decision-making would be all three. The memo suggests that the issue is merely removing an obstacle to Adams' ability to assist with federal immigration enforcement, but that does not bear scrutiny. It does not grapple with the differential treatment Adams would receive compared to other elected officials, much less other criminal defendants. And it is unclear why Adams would be better able to aid in immigration enforcement when the threat of future conviction is due to the possibility of reinstatement of the indictment followed by conviction at trial, rather than merely the possibility of conviction at trial. On this point, the possibility of trial before or after the election cannot be relevant because Adams has selected the timing of his trial. Rather than be rewarded, Adams' advocacy should be called out for what it is: an improper offer of immigration enforcement assistance in exchange for dismissal of his case. Although Mr. Beauvais disclaimed any intention to exchange leniency in this case for Adams' assistance in enforcing federal law, that is the nature of the bargain laid bare in his memo. That is especially so given the comparison to the Bout prisoner exchange, which was quite expressly a quid pro quo, but one carried out by the White House and not the prosecutors in charge of Bout's case. The comparisons to the Bout exchange is particularly alarming. That prisoner swap was an exchange of official acts between separate sovereigns, the U.S. and Russia, neither of which had any claim that the other should obey its laws. By contrast, Adams is an American citizen and a local elected official who is seeking a personal benefit, immunity from federal laws to which he is undoubtedly subject in exchange for an act, enforcement of federal law, he has no right to refuse. Moreover, the ballot exchange was a widely criticized sacrifice of a valid American interest, the punishment of an infamous arms dealer, which Russia was able to extract only through a patently selective prosecution of a famous American athlete. So, yeah, it was about, this is the one with Brittany Griner. She has in a footnote, I attended a meeting on January 31st, 2025 with Mr. Bove, Adams' counsel, and members of my office. Oh, wow. Adams' attorneys repeatedly urged what amounted to a quid pro quo, indicating that Adams would be in a position to assist with the department enforcing priorities only if the indictment was dismissed. Oh, wow. Mr. Bove admonished a member of my team who took notes during that meeting and directed the collection of those notes at the meeting's conclusion. It is difficult to imagine that the department wishes to emulate that episode by granting Adams leverage over it akin to Russia's influence in international affairs. It is breathtaking and dangerous precedent to reward Adams' opportunistic and shifting commitments on immigration and other policy matters with dismissal of a criminal indictment. This is horrible. Hers is worse. So she's saying she was at a meeting, y'all, and Adams was there with his attorney, and they were at a table, and that clearly there's not going to be no recordings, probably not going to be nothing that's memorializing this, because she's saying somebody that was in the meeting with her was trying to take notes, and they took her notes. This is crazy. So this is going to be something that a judge is going to have to probably come in. Federal judges have lifetime positions, so this might be something a federal judge is going to have to come in, because this is grimy. So anyway, let me see. Second, Mr. Bouvet states the dismissal is warranted because of the conduct of this office's former U.S. Attorney, Damian Williams, which according to Mr. Bouvet's, and I'm probably messing his name up, Bouvet's memo, constituted weaponization of government as defined by the relevant orders of the president of the department. The generalized concerns expressed by him are not a basis to dismiss an indictment returned by a duly constituted grand jury, at least, whereas here, the government has no doubt in its evidence or the integrity of its investigation. As Mr. Bouvet's memo acknowledges, and as he stated in our meeting of January 31st, 2025, the department has no concerns about the conduct or integrity of the line prosecutors who investigate and charge this case, and it does not question the merits of the case itself. Still, it bears emphasis that I have only known the line prosecutor in this case to act with integrity and in the pursuit of justice, and nothing I have learned since becoming U.S. Attorney has demonstrated otherwise. If anything, I have learned that Mr. Williams' role in the investigation and oversight of this case was even more minimal than I had assumed. The investigation began before Mr. Williams took office. He did not manage the day-to-day investigation, and the charges in this case were recommended or approved by 4 experienced career prosecutors, the chiefs of the SDNY Public Corruption Unit and career prosecutors at the Public Integrity Section of the Justice Department. Mr. Williams' decision to ratify their recommendation does not taint the charging decision. And notably, Adams was not brought a vindictive or selective prosecution motion, nor would one be successful. Regarding the timing of the indictment, the decision to charge in September 2024, 9 months before the June 2025 Democratic mayoral primary and more than a year before the November 2025 mayoral election, complied in every respect with longstanding department policy regarding election year sensitivities and the applicable justice manual provisions. Told you, she know her manual, okay? The Justice Manual requires that when investigative steps and charges involving a public official could be seen as affecting an election, the prosecuting office must consult with Public Integrity Section, and if directed to do so, the Office of the Deputy Attorney General or Attorney General. As you are aware, this office followed this requirement. Further, the Justice Department's concurrence was unquestionably consistent with the established policies of the Public Integrity. Public Integrity Section, Federal Prosecution of Election Offenses. That's another. She know her stuff. The Department of Justice correctly concluded that bringing charges 9 months before a primary election was entirely appropriate. The timing of the charges in this case is also consistent with charging timelines of other cases involving elected officials, both in this district and elsewhere. So she lists her authority of other people that, that were elected officials, and it was around the same time. I am not aware of any instance in which the department has concluded that an indictment brought this far in advance of an election is improper because it may be pending during an electoral cycle, let alone that a validly returned and factually supported indictment should be dismissed on this basis. When the first setting the trial date, the district court and the parties agreed on the importance of completing the trial before the upcoming mayoral election, including before the Democratic primary in which Adams is a candidate, so that the voters would know how the case resolved before casting their vote. Adams has decided that he would prefer the trial to take place before rather than after the June 2025 primary, notwithstanding the burden trial preparation would place on his ability to govern the city or campaign for re-election. But that is his choice, and the district court has made clear that Adams is free to seek a continuance. The parties therefore cannot argue with candor that dismissing serious charges before an election, but holding open the possibility that those charges could be reinstated if Adams were reelected, would now be other than clearly contrary to the manifest public interest. Jeez. She had a lot to say. She wasn't really as short, but this is the actual acting U.S. attorney, which is the one that took Damian Williams' spot once he left. So that's why she's saying a lot before she resigned. Mr. Beauvais' memo also refers to recent public actions by Mr. Williams. It is not my role to defend Mr. Williams' motives or conduct. Given the appropriate chronology of the investigation and the strength of the case, Mr. Williams' conduct since leaving government service cannot justify dismissal here. With respect to pretrial publicity, the district court has already determined that Mr. Williams' statements have not prejudiced the jury pool. Yeah, that was a motion that was already filed by the court. So that's why I said it's kind of like it sounded like to me, this is before I even knew about the meeting, because I'm just not reading this for the first time, that this sounded like some arguments that his attorney were waging at this meeting. The district court has also repeatedly explained there is no evidence that any leaks to the media came from the prosecution team. Although there is evidence media leaks came from the defense team and no basis for any relief. Mr. Williams' recent op-ed, the court concluded, generally talks about bribery in New York State, and so is not a comment on the case. And it is well settled that the U.S. Attorney in this and other districts regularly conduct post-arrest press conference, CUS v. Avenatti. New Jersey, she got her authority for everything. Moreover, dismissing the case will amplify rather than abate concerns about weaponization of the department. Despite Mr. Beauvais' observations that the directive to dismiss the case has been reached without assessing the strength of the evidence against Adams, Adams has already seized on the memo to publicly assert that he is innocent and that the accusations against him were unsupported by the evidence and based only on fanfare and sensational claims. He definitely did go out and do a press conference, and his attorney said, we've always maintained his innocence. He never did anything. But it sounds like to me this is a quid pro quo from a meeting. And this man who did this memo, originally saying to dismiss it, he acknowledged that he has not weighed the facts of the case. So he doesn't know one way or another whether this was not done because they believe you're innocent and you're being unfairly targeted and you're really innocent. They trying to get your help on their agenda is what it sounds like. This is crazy. And this is my profession. This is crazy to me. Oh. Mm-mm-mm. Confidence in the department would best be restored by means well short of a dismissal. As you know, our office is prepared to seek a superseding indictment from a new grand jury under my leadership. Whoa. We have proposed a superseding indictment that would add an obstruction conspiracy count based on evidence that Adams destroyed and instructed others to destroy evidence and provide false information to the FBI, and that would add further factual allegations regarding his participation in a fraudulent straw donor scheme. So they planned on they weren't trying to dismiss this case, they were trying to supersede and add more counts. This is more than enough to address any perception of impropriety created by Mr. Williams' personal conduct. The Bove memo acknowledges as much, leaving open the possibility of refiling charges after the 2025 New York City mayoral election, nor is conditioning the dismissal on the incoming U.S. attorney's ability to reassess the charges consistent with either the weaponization rationale or the law concerning motions under Rule 48A. To the contrary, keeping Adams under the threat of prosecution while the government determines its next step is a recognized reason for the denial. And they say, see U.S. v. Poindexter, which stands for the proposition allowing government to keep open the option of trying certain counts would effectively keep the defendant under public for an indefinite period of time until the government decided, what they want to do. Adams' consent will not aid the department's argument. Mr. Bove specifies that Adams must consent in writing to dismissal without prejudice. To be sure, in the typical case, the defendant's consent makes it significantly more likely for courts to grant motions to dismiss under Rule 48A. But Adams' consent, which was negotiated without my office's awareness or participation, would not guarantee a successful motion, given the basic flaws in the stated rationale for dismissal. Seeking leave of court to dismiss a properly returned indictment based on Mr. Bove's stated rationale is also likely to backfire by inviting skepticism and scrutiny from the court that will ultimately hinder the Department of Justice's interests. And particularly, the court is unlikely to acquiesce in using the criminal process to control the behavior of political figures. A brief review of the relevant law demonstrates this point. Although the judiciary rarely will overrule the executive branch exercise of their prosecutional decisions, courts, including the Second Circuit, will nonetheless inquire as to whether dismissal would be clearly contrary to the public interest. Okay, then they got a bunch of authority. The assigned district judge, the Honorable Dale E. Ho, appears likely to conduct a searching inquiry in this case. Notably, Judge Ho stressed transparency during this case, specifically explaining his strict requirement for non-public filings at the initial conference. And a rigorous inquiry here would be consistent with precedent and practice in this and other districts. Nor is there any realistic possibility that Adams' consent will prevent a lengthy judicial inquiry that is detrimental to the department's reputation, regardless of the outcome. In that regard, although the Flynn case may come to mind as a comparator, it is distinct in one important way. In that case, the government moved to dismiss an indictment with the defendant's consent and faced resistance from a skeptical district judge. But in Flynn, the government sought dismissal with prejudice because they had become convinced that there was insufficient evidence that General Flynn had committed any crime. That ultimately made the government's rationale defensible because insufficient evidence is a quintessential justification for dismissing charges. Here, no one in the department has expressed any doubts as to Adams' guilt. And even in Flynn, the president ultimately chose to cut off the extended and embarrassing litigation over dismissal by granting a pardon. This is a lot. Hey, y'all. Jay the Baker W said he must be thinking he's a white ghost. You know what? Happy Valentine's Day, Sonia. Why don't these criminals schedule their crimes accordingly so they don't conflict? you know what? Thank you, a sister from New Jersey, for the super sticker. I appreciate that. Thank you for the gifted memberships. I appreciate that. Cassandra said Trump is on get back with New York due charges they brought against him, which mirrors Diddy's, but nobody's talking about that. Eric Adams is a pawn. He will dismantle SDNY to get his way. Yeah, this is clearly all political, and we're supposed to be separate. That's why we have separation of power between the executive, legislative, and judicial branch, and that keeps a balance of power so that no one entity has power. But the problem is when you get a president that puts his people into place, this is the stuff that you have. And eventually, I mean, right now, these people are resigning and they're not going to have a problem getting a job. And I'm sure it's disheartening that they have to resign, but eventually he'll get somebody that's willing to play ball. And that meeting, it just really sounds like you're there with your lawyer. What does your criminal lawyer need to be there if you guys are talking about immigration or talking about things, conducting business from about your city as the mayor? What does your lawyer need to be there for? Your criminal attorney. This is crazy. He said the buffoonery these people in a position of power politically is very shameful. Yeah, it's crazy. It's crazy. Okay. So then she ends with the last, I think this is the last part where she says, I cannot in good faith request the contemplated dismissal because the law does not support a dismissal and because I am confident that Adams has committed the crimes with which he is charged. I cannot agree to seek a dismissal driven by improper considerations. As Justice Robert Jackson explained, the prosecutor at his best is one of the most beneficent forces in our society. When he acts from malice or other base motives, he is one of the worst. I understand my duty as a prosecutor to mean enforcing the law impartially, and that includes prosecuting a validly returned indictment, regardless whether its dismissal would be politically advantageous to the defendant or to those who appointed me. A federal prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern to all. For the reasons explained above, I do not believe there are reasonable arguments in support of the Rule 48A motion to dismiss a case that is well supported by the evidence and the law. I understand that Mr. Beauvais disagrees, and I am mindful of your recent order reiterating prosecutors' duty to make a good faith argument in support of the executive branch's position. But because I do not see any good faith basis for the proposed position, I cannot make such arguments consistent with my duty of candor. And then they cite the rules of professional conduct for lawyers, that a lawyer acting as an advocate in an adjudicative proceeding has an obligation to present the client's case with persuasive force. Performance of that duty while maintaining confidence of the client, however, is qualified by the advocate's duty of candor to the tribunal. In particular, the rationale given by Mr. Beauvais in exchange between a criminal defendant and the Department of Justice, akin to the bout exchange with Russia, is as explained above, a bargain with the prosecutor should not make. Moreover, dismissing without prejudice and with the express option of again indicting Adams in the future creates obvious ethical problems by implicitly threatening future prosecution if Adams' cooperation with enforcing the immigration laws proves unsatisfactory to the department. That's what it sounded like to me. But I guess Adams said he just want to get out from under this indictment right now. Finally, given the highly generalized accusation of weaponization weighed against the strength of the evidence against Adams, a court will likely question whether that basis is pretextual. I remain baffled by the rushed and superficial process by which this decision was reached in seeming collaboration with Adams' counsel and without my direct input on the ultimate stated rationale for dismissal. Mr. Beauvais admonished me to be mindful of my obligation to zealously defend the interests of the United States and to advance good faith arguments on behalf of the administration. I hope you share my view that soliciting and considering the concerns of the U.S. Attorney overseeing the case serves rather than hinders that goal, and that we can find time to meet. In the event you are unwilling to meet or to reconsider the directive in light of the problems raised by Mr. Beauvais's memo, I am prepared to offer my resignation. It has been and continues to be my honor to serve as a prosecutor in the Southern District of New York. And that is the end of her letter. And that was to General Bondi. So, what are your thoughts? Trump is on to get, okay, I already read that, but that's it, child. That's the end of it. We have read, that is what is going on. So now, again, we are waiting on the dismissal. I don't know if the dismissal come. I probably just posted. I don't know if that'll be worth the whole live. But right now, they just trying to find somebody else that's willing to do it. Somebody, anybody in the chat willing to go ahead and go work for the Southern District of New York so that they could file something on behalf? Let's see, something was filed since we've been on here. Let's see if he got a Valentine's Day gift. No, nothing. They filed a protective order with respect to certain classified materials as to Eric Adams regarding procedures to be filed that shall govern the handling of the material. So it sounds like they still filing stuff on the case as if it's still going on. Yeah, so there's still people out here. Again, I felt like it was worthy of discussing. Especially since, people just think everybody is just going along to get along. But there are people, and expected in the future, there are going to be a lot of other people that are probably going to come forward and eventually resign because they are asked to do things that they took an oath that they would not do, or even just their own personal convictions that they won't do. And I think we're going to get a lot of that in this administration. But in the interim, make sure you guys hit the like button. Subscribe to the channel if you have not done so already. Girl, a whole mess really be a whole entire mess. Well, that's it. I hope you guys have a fabulous Valentine's Day. Let me see if I missed any. You said female standing up to the champ. Hold your wigs. We are in for a ride. But Pam doesn't 4547 want these government employees to resign. Could this be 3D or 4D chess from 40? This is a part of, so what it sounds like to me based on this, of course I wasn't in the meeting, but what it sounds like to me is that Adams and his attorney went to a meeting and they in DC, and it sounds like the acting U.S. attorney was there, which is the letter we just read, and some of the other AUSAs, assistant U.S. attorneys that were on the case for Adams, and it was a discussion. And in part of that discussion, apparently part of the discussion was Adams was making it seem like, oh, he is such an advocate for Trump's wanting to do with this immigration, like his immigration policy. He is pro-immigration, but having this indictment over his head has hindered his job in implementing some of the policies for immigration. And then that's probably what the crux of it was just, and so this is why this acting U.S. attorney was like, listen, I was at the meeting and it sounded like quid pro quo, because that's probably how it was presented. Like, listen, We can't have this. The fact that this indictment is going on, and then to bring up the fact that this has happened during an election cycle. Remember, Trump just went through that. I mean, it seemed to help him though, but he just went through that. So just remember, his attorneys were also trying to get adjournments and dismissals based on it affecting his election. So they sat back, and it sounds like they just kind of strategized of, well, let's try to find something that would cater to this administration and say that this is unfair. But then, in order to protect themselves, it sounds like the administration said, oh, yeah, we'll go ahead and dismiss this, but we're going to do it without prejudice. So that means we can bring it back. So he always knows he's always under scrutiny, which is still unfair for a defendant as well. You're always under scrutiny. You're always under, I guess, the fear of them re-indicting you if you don't do what they want you to do. And so she basically spelled all this out quite eloquently. And that's probably why when this other person decided they were about to resign too, theirs was quick and straight to the point, because they were like, I agree with everything that she said. And that was that. It was, they was like, if no lawyer within earshot of the president is willing to give him that advice, then I expect you will eventually find someone who was enough of a fool or enough of a coward to file your motion. But it was never going to be me. Please consider this my resignation. Theirs was a nice little text message almost, right? So this went directly to the acting U.S. attorney general. But they just said, I concur with everything that she said. And we just read everything she said. She put in case law and she thoroughly analyzed it. So that's it. Instrand said, Pam, isn't the whole part that federal judges are now stopping them from filings? They are. So getting them to resign all by themselves sounds like it does. That's why people have been trying to encourage federal workers not to resign. That's why I've seen TikToks where they don't even have offices to go into. How do you order people back to offices that don't exist? So literally they're showing TikToks of 30 people being in one room, crowded, that's not even designed to be an office, with cubicles. You could hear everybody's conversations. Nobody can, because they weren't, some people were hired as remote workers. So that's exactly what you were. So if they hired you as a remote worker, it wasn't because you were at a building at first and then they made it remote. So they don't even have positions. They don't have places for these people to be. So why these people are resigning, I think perhaps maybe it's a conviction within themselves, or they just don't want to work under this administration. That could be possible. But otherwise, yeah, I would be sticking it out. You said what? I got to show up to where? Oh, the public library as my office for the day? I'll be there because it's too many people. There's no way that they can accommodate all these people, and eventually they'll have to go back to remote. So Miss Lady said, right, asking them to do something they don't want to do as a way of pushing them out. Yep. This is crazy how this is going, but I'm just sitting back. Hood mayor of New York said that's how Spiro is. He's willing to do anything unethical. That's why he charges so much. Well, that's what he's going through. I don't know about all that, but I do know that Busby has made allegations. But people looked at Busby a little side-eye too, but everybody's made allegations towards each other related to their ethics. And sometimes people are money driven. I'll drop a client in a minute, or I won't take a client in a minute. If I don't believe in you, it's a wrap. And what I do again now, primarily I do is wrongful convictions. And if I feel like you come to me and I feel like you did it, I ain't representing you. So I think you do have to have your personal convictions as well. And it can't be driven by money, because money is not everything. You can always make more money. But being willing, like the people, those attorneys that went to being Donald Trump's fixers and just happy to be around Donald Trump, There are attorneys like that are willing to do it's a lot of attorneys out there that would be willing to do whatever the client wants them to do because of who the client is. I'm not one of those. You're not going to ask me to file a lawsuit that I know is frivolous and ridiculous just because you're Rihanna or something. That's not going to happen. I don't do that. So if you don't have a case, I tell you, you don't have a case. Now, that's not discouraging you. In my opinion, I'm not going to put my name out there and put it on your case. But I encourage you to go seek other attorneys and see what their opinions are, because there'll probably be someone out there that thinks differently than me. But that's definitely something that every attorney has to face is, are you willing to just take any case? Now, when it comes to defense, everybody, you have a constitutional right to it. And that's a whole nother conversation. People ask, well, how do you defend people that you know did it? And they go through all that. I've never actually been in the, I'm not going to say I've never defended anybody just hasn't done anything, but I've never done court appointed. So every time that I've defended a criminal defendant, it's because it was my choice when I did do criminal law. So I don't have that, but when you do court appointed, you don't have a choice. You got to take whoever they assign you to, or they'll kick you off the list. And a lot of criminal defense attorneys, it's a hustle. So sound like Spiro out here making his money though. I guess he's giving people their money's worth. Anyway, he fired 3,000 already. Wow, Sherman. That's crazy. Oh, you're welcome. I don't know if it was me. It might have been somebody else. We had a few people give gifted memberships. Thank you guys for the super chats. We had a goal today. We got two out of our goal. We had a goal of 5. We did get some memberships. I had my memberships. Van C gifted 5 memberships, and it's the Rocks gifted 5 memberships as well. Michelle K said, now's the time to fight for the democracy where only soldiers had to fight before. That is true. Everybody has a position and a place. This is times that we've never seen before. So Dems need to start campaigning now for the midterm election. They should have been campaigning as soon as, see, this is where the Democrats jacked up. First of all, people need to be more educated that the legislative branch is very important, but we always focus on the president. So then when you lose the House, you lose the Senate, everybody's like, oh my God, nothing can pass. Like the president can only do so much. So now the president is important as far as the Supreme Court because they're the ones that nominate and all of that. But I think we focus on the wrong stuff. How it used to be was they would almost groom you from high school and know if you were going to be a politician. And so you would start out at your local little city council. They'd be 20 years old. Then all of a sudden they running for mayor at 25. And you can kind of see the ones that are climbing the political ladder to go to different places. And the Democrats, like I used to get emails a lot when they're looking for women or they're looking up for minority women. They'll teach you the process. They'll teach you about government. They'll almost train you. I used to get those all the time. So if you're interested, they'll start training you, and then like you lead up to it where you're training for a certain amount of time. When Biden got into office, it was clear that he was what we call a transitional president. It was very unclear if he was going to make it through the first term, let alone a second one. Therefore, because people don't know government like that, one of the biggest mistakes is if they wanted Kamala Harris to be the one that was going to come after him, then she should have been more in the forefront, because people don't understand that a VP doesn't do much. All we see out here that don't know the government is, oh, now she want to come to my city now that she running. Where was she at the last 3 years? We ain't seen her do nothing, even though in theory she's not much for her to do like that. She got duties, don't get me wrong, but it's not what the public thinks that they are. So if that was really her being the person that basically took Biden's spot at the last minute lets you know that the Democrats weren't prepared at all. As soon as Biden got into office as a transitional president, they should have been grooming people for every position that they're trying. That means for the entire 4 years, there should have been these same names should have been repetitively out in the public that we would have got so sick of hearing their name that if we seen it on a ballot, we would just check it because that's the names that we saw. But that's not what they did. We just Biden all of a sudden at the last minute, it was like he looked so horrible at that debate that now he can't. Now you got Congress telling him you better step down or we're going to do articles of impeachment, and he was pretty much forced out, and they weren't prepared. But to me, you seen Biden came in there. Yes, he appeared more cognitively sound when he first got in there. But I mean, he's getting older. Progressiveness of age. And I've never seen the Democratic Party this unprepared. They're just unprepared. They don't groom people. They don't like mentor people. They don't put behind people. You don't see a lot of their kids sitting with them, teenagers sitting with their parents that are in politics. You don't see any of that. So it's a lot of generational stops. It was a generational thing a lot of time with politicians, because it was like if you were a kid and you grew up in a home with a politician, it was almost expected you were going to be a politician. And so you knew all about it. So you have a lot of generational politicians. We don't have that anymore. So yes, thank you so much, Sherman, for the super sticker. I appreciate that. Diamond Pearl, thank you. You said they knew Biden was not good for a second term. Absolutely. Yeah, he was. You're right, Santivia. She brings up a good point. He was forced to run the first time because there was nobody else. So they were unprepared. And honestly, Trump resonated with a lot of people. He is really what a lot of Americans are. We may want to bury our heads in the sand. They tolerated a lot of the changes that we've had of the civil rights movement. They tolerated women being allowed to do certain things and minorities. They tolerated it. But deep down, there are non-melanated people who believe that they are superior. Let's just be clear. And to have someone that doesn't care, don't really know politics, don't even know the heck the Constitution, to come out and just say what they feel and don't care, even if it doesn't make sense, even if it's name calling, any of that, they didn't care because that was more what they resonated with. They don't care about his policies because he never really gave any policies. To say your eggs are going to go down, is that really a policy? And how are you going to affect that when eggs went up because of what, like the bird flu or something? Like what you're saying makes no sense. But when people don't know and you're talking to people that are ignorant, then you can say stuff like that and they can be geek. Now everybody got buyer's remorse right now. I'm just sitting back. But I just wanted to shout out my fellow sister councils and brother councils that's out here and they're saying get somebody else to do it. I am not going to compromise my integrity to do something that I know I have no arguments. We do have a duty of candor. Now, do I feel like some people argue in court and they really know they ain't got no argument? Absolutely. But you do have a duty of candor when you know that you really don't have a leg to stand on. And usually you just say, I'm not going to concur. I just leave it to the discretion of the court. Like you don't just concede, but you say when you get something and you know you don't really have an argument, you're like, yeah, I leave it to the discretion of the court. Whatever you say, because I'm not about to go to my client and say I just gave up. But sometimes you really don't have arguments. It does happen. And so this is what this acting U.S. attorney was saying. Like, I don't have any arguments to file this motion that you want me to do based on what you're saying you want it to be based on. I don't agree with it. And I'm not going to stand up here knowing that I took an oath and I'm going to argue this trash because basically there was a barter deal between you and Mayor Adams in order for him to implement policies that you want him to implement in New York. And then you're still holding it over his head that basically if you don't do what we ask you to do, then we may bring it back. So that's pretty much how she worded this letter. So that's it. No worries, these times will resonate with our youth to become more involved in politics is a must. Yeah, I think so too. I think that's one of the good things that may happen out of this is that now people are going to get more interested and more involved in politics. It's not as boring as people think it is. Thank you so much, B Crumbs, for gifting 5 memberships. Assuming broken clock theory is right, 45 and 47 finally being competent, getting U.S. government attorneys at DOJ to resign themselves instead of firing them and then fighting in court. I believe that, I hear what you're saying. I believe that he's going to find someone, like I said, that is going to file this motion as asked and requested. And then the judge ultimately can deny it. As she says, she's just saying, I don't have an argument. His arguments are strong. I don't believe in his argument. I ain't about to sit up here and fake the funk. That's basically what she's saying. So the judge still can deny the motion. So, the headlines are saying that the DOJ ordered to dismiss the charges. And I think it was improper. Well, I ain't going to say improper, but I think it was, Mayor Adams should not have responded to that DOJ request and did a little, he shouldn't even talked about it because they know I'm innocent. No, that man's letter said he ain't even looked at your evidence. He just feel like you could be helping them out more if you didn't have to worry about this indictment. That's really all he said. He acknowledged, I don't know nothing about the evidence at all, which is crazy to say. I really don't know if he did it or didn't do it, but I just feel like, y'all could wait and do this later. We want you to hold off a little bit. We know a grand jury, an impaneled grand jury is the one that brought this indictment, but yeah, we think you could wait a little bit longer till he carries out, what we need him to do. So, politics is the best reality show right now. It is, Cynthia Cage. So, is she? I don't know. All right, you guys. Again, happy Valentine's Day to each and every one of you guys. Thank you guys for hanging out on our political corner. We rarely do our political corner over here, but this is what's going on with Mayor Adams. And hope you guys enjoy the rest of your day. But I'm going to get on off here. This was way longer than I thought it was going to be. That's because I seen her letter, and before I wasn't going to do her letter because I hadn't even seen it. I was just going to do the little letter that I thought was funny. But so yeah. All right then. Let's get out of here, and we may be back later depending on if some documents drop on some of our other cases that we are covering over here. But until then, y'all have a good day.